Houston Real Estate Radio starts right now.
Welcome back to Houston Real Estate Radio. Thanks for tuning in this Sunday afternoon. I'm Shannon Register.
I'm James Brown.
And a few weeks ago, we had, we've talked a lot in detail, actually over the last several weekends, we've talked a lot in detail about the landlord-tenant relationship. We've discussed property management and how investors, we've had different opinions on how investors need to set up LLCs to put all of their rental properties in. We've really, we talked with Gary Cooper about the tax implications for landlords. So we've had a lot of discussion about the landlord-tenant relationship. And so really, one of the things we haven't talked about is what you do when someone stops paying you and they haven't moved out of the house. Yeah. When you really start having issues. We've heard some horror stories about about tenants.
Listener question last month.
Yeah.
Or last week.
Last week, yes. So it's been interesting. But today I want to talk about the eviction process and what people have to go through, what landlords have to go through when they have issues with their tenants. Brian Cweren, who's the founder and owner of the Cweren Law Firm, myapartmentlawyer.com, is joining us in the studio, and he focuses on representing landlords. Welcome to the show.
Thank you very much.
So, first of all, I want you to walk us through the whole eviction process, because I think so many people become landlords and they never even think about the fact that they could potentially have to evict someone one day. And I don't think they even know what that entails. A lot of people never have to do that. So is it very common for landlords to have to evict people?
Well, we certainly keep 16 courts, the Justice of the Peace Courts in Harris County, busy. After all evictions do start in the Justice of the Peace Court. If it's a multi-million-dollar tenant or a $50 a month tenant, everyone's going to go through the same process. They're all started the Justice of the Peace Court and work their way up, and there are thousands and thousands of those cases that are filed, and it is a common occurrence. But you have your individual landlords that rarely have to go through it. But it certainly shouldn't be an intimidating process. It is not all that complicated, but sometimes it can get.
Well, take us through it and start with the tenant isn't paying the rent and go from there.
You bet. Tenant's not paying the rent, or a second track, maybe the tenant's doing something they shouldn't be doing. Mm-hmm. You go down, first you have to start with your lease, any special requirements you may have to give, notices you may have to give. Certainly in Texas, we require a 3-day notice as a minimum, as a default. In some cases, a 10-day. You give your notice to vacate. You then let that time pass. You want to make sure that notice to vacate is served properly. The Texas Property Code that rules the way that landlords are supposed to operate in Texas sets out those requirements, and you want to make sure you're in compliance with that.
And you can find those online, by the way.
Yes.
So
yeah.
There's a lot of them.
And that's but it shouldn't be intimidating. You want to read Section 24 of the Texas Property Code and become familiar with how you can deliver that notice to vacate. So you issue your notice to vacate. The certain time has passed. The tenant has not left. You go down to your Justice of the Peace Court. If you're not sure which one governs your area, call the constable. Call one of the courts. Give them the address, and they'll steer you to which court to go to. In Harris County, at least, you are going to have an option of 2 courts, 2 judges in your area, one of the different precincts, and you're going to go and pay your filing fee. The constable is going to serve that person. I have clients call and say, well, I know they're going to hide. That's okay. We have a process set for that. The constable will make a certain number of attempts, and if they don't answer the door and they hide, they're going to get the court's permission to simply tape it to the front door. And you have a ball game going. They're going to have a trial date. You will go first in front of the judge and tell them why you're evicting the person, show your notice to vacate, and the tenant, if they show up, will respond, give their side of the story, and the judge will make a ruling. They have 5 days to appeal it, or you can purchase your writ of possession. But you certainly don't want to think, well, I've gone to court, I won, I'm going to go throw the tenant out. You have to go through that towards that final step, the writ of possession, and paying the constable a fee, they go out there and they will contact you and make an appointment with you to come and meet you at the property and move the tenant out. And you certainly want them to do their job and not short circuit the eviction process unless they appeal it. But pretty much that is the eviction process.
If you're not paying your rent and someone's trying to evict you, how likely are you to win that appeal?
Well, people appeal it from JP court all the time, and the primary reason they do it is to buy time. That's one of the more that's probably the number one reason they do that. We certainly did recently change laws. You can appeal for the better for the landlord. You can appeal under one of three ways, from the JP judge to county court, and that is the next level, county court. And we have 4 county court judges here in Harris County. You can appeal it by posting. The tenant can post the cash bond, and they're almost always not going to do that. The common method is number 2, where they say they're a pauper, and they under oath say they don't have any assets, and they appeal it by filing that pauper's affidavit. And again, it has to be timely. It has to be done within 5 days of that judge making a ruling. The third avenue that you don't hear much about is they give a paper bond or a surety bond. It's where 2 other residents of Harris County say they're going to stand good for that judgment against the tenant, and that enables you to appeal it. So those 3 methods get the tenant to be able to appeal it up to county court.
So let's say in an instant where you've got a college person in your rental property, and they haven't paid rent in 3 months, and then they realize that you're going to evict them, and they go to mom and dad and want the money, and mom and dad say they'll take care of it, they'll fix it. They could present those letters and possibly and pay it and possibly keep the tenant in?
Well, that comes back to the landlord. I know that we have some judges in town that feel that as long as the tenant offers you that money, even right in front of them on the day of the trial, that somehow the landlord has an obligation to accept that money, and no, they don't.
But they're pretty mad by then. So,
and that's the discretion of the judge in some cases.
We have some judges out there who seem to think that as long as the tenant's standing there and has the money, that the landlord should take it. But that's not really what the law says. Mm-hmm. If that tenant, you enter into a lease and you have terms and conditions of that lease, and the number one is that to pay the rent and pay it on time. If the tenant doesn't pay it on time, they're in default, and it's up to the landlord as to whether or not they're going to accept that late rent. Mm-hmm. Now, if you have a pattern of constantly accepting that late rent, there's a principle called waiver, where you've changed the way the parties conduct business, and you can't really go into court with clean hands and say, well, they didn't pay on the 1st, because it's a good defense to say, but you, the landlord, have accepted that rent on the 10th every month for the last year. Yeah. I would say you have a problem, and you need to accept that late rent at some point.
I see a lot of landlords doing that. They'll take the late rent, or they'll take the late rent without accepting the late fees, and then they try to collect the fees at the end of the lease, and then they go to court and say, well, you weren't collecting these fees before. Why are you trying to collect them now?
Yes. But keep in mind, at the JP court, that's going to be strictly about the rent only, not fees, not other issues. And so, but the judge is not correct if they say, well, you need to take the tenant's money. They've got it right here in their hand. And if you have a judge that treats you that way, then and they rule against you because you're not going to take the rent, the landlord would then just appeal it up to the county court.
I would appeal it, because once they're mad at me and know I'm going after them legally, there's no telling what they're going to do to the inside of that house if I do let them back in.
Certainly. And I get that question a lot from people, which kind of goes back to even before your lease, is you really want to spend the time to screen your tenant. Mm-hmm. That's one of the, I try to remind my clients all the time, catch this on the front end.
Yeah, we've talked about this a lot.
Yes, we have. Yes, we have.
And I know it's not easy when someone waves cash in your hand, but you have to take a minute to say, especially if you're an independent operator, you're going to have tenants out there who know that they can't go to the big management companies in town and rent from them because they don't qualify. They may have a criminal record, a felony. They may have a history of bouncing around. I know that in my office, and we devote ourselves to evictions, we have frequent flyers and repeat tenants that we're evicting all the time because they keep landing at different clients who don't catch it. Or they keep suing clients. We have people that we have to be careful to keep up with their cases because they're suing multiple ones of our clients, and,
Wow.
and they move out of one apartment complex, sue them, move into the next one, sue them. But you really need to screen your tenant from the very beginning, and there are many services out there that will do that and have your rental criteria in line with that. And I tell you what, one of the best kept secrets is a lot of stuff is free if you spend the time. Get on the different courts' websites. You certainly don't have the time to check every single court, but plug in this potential tenant as a defendant and see, have they been evicted somewhere else, or plug their name in as a plaintiff. Who have they sued and why have they sued them? Do you really want to do business with if they're going around suing landlords, is that someone you really want to have on your property?
That's a good idea.
But certainly check the court websites. If you feel that they're always in your part of the county, then there would only be a couple courts to check. But I would strongly recommend that everyone use a screening service, or at least on their own, to make sure you're getting the right person in your property before you even have to worry about these other issues.
Can you stay with us?
Absolutely.
Okay. This is Houston Real Estate Radio. Shannon and I will be right back after this short break.